Happy National Disability Employment Awareness Month, and thank you for attending today's webinar entitled Requesting and Negotiating Workplace Accommodations. Our presenter for today is Lisa DeMoss, consultant on the Cognitive and Psychological Accommodation team for the Job Accommodation Network. Thank you so much for being here today, Lisa. I'll go ahead and hand it over to you.
Awesome. Thank you, Courtney, so much for having me. I am just thrilled to be here today. I'm a Midwest girl myself. I do reside in Missouri and work remotely for Jan. So yay, I'm glad to talk to somebody in my time zone. Okay, so our topic today that we'll be discussing, or I'll be presenting, is on how to request and negotiate workplace accommodations under the ADA. So I do want to introduce everyone to JAN, or the Job Accommodation Network, in case you are not familiar with us, and give you an overview of our services. Also give a very brief overview of the ADA as it applies to Title I employment, talk about disclosure and issues around disclosing a disability, and then give some strategies and guidance on the interactive process for requesting and negotiating an accommodation. I'll start out talking a little bit about JAN. JAN is a national service. It is free. We do provide consultation on the ADA employment provisions, which is also referred to as Title I of the ADA. It has existed in some form since 1983, which is even earlier than the actual federal ADA law was in place. The University of West Virginia had a job accommodation program in place prior to that, and were easily able to get the grant for the federal job accommodation consultation service. We are currently the leading source of expert guidance on the interactive process, job accommodations, and Title I. And we are under the Department of Labor's ODEP, or Office of Disability Employment, which we are a federal grant. We have not been impacted by the shutdown, but some of the services at our funders level have been impacted, but we are open and serving the public for our grant this year. Our website is very simple. It's askjan.org, and I will be discussing some of the services on the site as we go through. So what does JAN do specifically? We can help with strategies for what the accommodation process might look like. We can definitely provide ideas for accommodation solutions. I am on the cognitive neuropsych team. We do have a sensory team and a motor team. I know brain injuries can be very involved with multiple different areas affected. So if I can't answer a question, then our motor sensory teams may be able to do that if vision is affected, if motor coordination is affected. So we do have specialty areas within JAN for specific accommodations. Again, it is Title I that affects employment accommodation, and that is our area of expertise. We even have one individual who helps people who are self-employed or interested in self-employment with that process, and she has a lot of resources for that type of accommodation. So again, our teams are general ADA, cognitive neuro, which is my team, motor and mobility, sensory immunology, and then our self-employment team. And under the sensory, we do have somebody that's quite versed in AT, assistive technology, that I utilize her skills a lot. For employers, we'll talk to anybody, but for employers specifically, we can help them brainstorm accommodations, help understand their obligations under Title I. We never give legal advice or advocate for one side or the other. We don't enforce the law, but we can be a neutral third party, and a lot of HR professionals like to contact us just to have somebody as a sounding board to talk about what they're planning on doing and how it may fit within the guidances that we have for how to implement the Title I provision. So for individuals with disabilities or family members or advocates, we talk to rehab professionals, we talk to job coaches. What do we do for that group? We can give very practical information about requesting and negotiating accommodations, giving different ideas for accommodation solutions, and giving basic information about, what the EEOC has said the employers may provide and things that aren't reasonable. For example, it's generally not acceptable to ask to remove an essential job function or to lower a production standard, but we might be able to give you ideas for how to meet that performance standard or production standard with an accommodation. So we can give information about what might be reasonable to request and what examples are of that particular accommodation. On our homepage, we do have a particular tab specific for individuals with specific commonly used resources that may be helpful in the process. We are available via email, telephone, live chat, or email. If you don't get a consultant, a message will be provided to the consultant and we will contact you via email, usually within a day or two. I think we pride ourselves on our promptness of this. So when you call, chat, or email in, you'll get a program assistant who will filter out who to connect you to based on your question. So, as I said, we work in teams. So if it's a cognitive, neuro, or psychological type disability, it may come to me or one of my teammates. If it's a motor issue or an accessibility issue, it's probably going to go to the motor team. So it's filtered out. And if it's a general accommodation question or a question about other aspects of the ADA, you may get one of our managers who works on the ADA lineup to answer that question, or you may get a referral to another agency. I got a call today about how to implement FMLA, and I don't know because I don't specialize in FMLA, but I do know the agency that does at the federal level, and I'm able to give a referral. Then the program assistant's going to put you in touch with a consultant, and then that's where you're going to get strategy, solutions, and guidance. This is a screenshot of our website. And if you notice the white ribbon that starts with the word employers in the middle there, employers, individuals, that can help if you go to the individual tab, if you're working as a employee or you are a support person or family member of an employee, that page can give you some really basic FAQs, a basic guide to the ADA accommodation process that's in question and answer, and then some resources for common issues, such as your accommodation was denied, or they haven't responded, or they're taking a long time to respond, or they want more medical, or they gave you an accommodation, but it's not effective. We have some really good, just basic resources on that page. A to Z is really just that. It's by disability, it's by limitation, it's by topic, it's by accommodation, from A to Z. Situations and solutions is kind of neat because you can look up accommodations by job category as well as disability. And then publications is very overwhelming, I think, to the public, but it is a list of all our publications. And I do get calls from both individuals and employers who say, well, I looked and looked for a resource on service animals. I could go right to it. And that's the benefit of having a live service. We can really help synthesize what's on our website and help you find it much more quickly than you sifting through it, because believe me, it took me a couple of years to get adept at navigating all of the resources on our website. We also offer live training like today, or we have monthly webinars that you can sign up for on different topics. Okay, the ADA overview. I don't want to spend a lot of time on this because probably most people have some idea that the ADA exists, but there are several titles to ADA, and the first one is Title I, and that is the area that Jan specialized in. It is Title I, employment to remove barriers for equal employment for individuals with disabilities who are basically qualified for the job. It prohibits discrimination on the basis of disability in employment, and it requires that reasonable accommodations be provided unless they cause an undue hardship for the employer to provide. In 2008, there was a major amendment to the ADA that broadened the definition of disability and started to include a lot more what I call invisible conditions, mental health conditions, things of that nature. And when that occurred, I know Jan expanded quite a bit. The ADA is enforced by the EEOC. And there's a link here to the EEOC's webpage. They are not active currently because of the government shutdown. So I'm sure they're going to have a lot of work to do when that's resolved. But they are the agency that would hear a charge from an employee. They do have a number that you can contact as an employer when they're open. That is not right now. And they print dozens of guidances on the ADA and many on specifically the Title I section of the ADA. And that is generally the primary source that we use to provide consultation, is the guidance that comes from EEOC on how to implement ADA accommodation processes. Let's go into some definitions. What is a reasonable accommodation? What does it mean for it to be reasonable? So in general, a reasonable accommodation is a modification or adjustment to a job or the work environment that permits an applicant or employee to participate in the hiring process, perform the essential job functions, or enjoy equal benefits and privileges of employment. So what does that mean? It's reasonable. Generally, that is a legal term that means feasible or plausible, possible to provide without undue hardship. And that can be interpreted in the courts even to this day. But with EEOC guidance, sometimes I'm able to give you a pretty good idea about reasonableness, and other times I get asked that question and I cannot weigh in because it will just be my opinion and not a legal stance. But there are a few things that the EEOC says, like my example earlier, removing an essential function. In other words, a function that the job exists for is generally not considered reasonable. But other areas of undue hardship is a little bit harder and sometimes up for interpretation. But the employer does determine undue hardship. And that is next defined as an action requiring significant difficulty or expense. Now, the difficulty thing, there are some guidelines, like I said, removing an essential function, seriously impacting others' ability to do their job is often cited as undue hardship. But expense, understand that if you say, well, it's too expensive to buy a $500 piece of equipment, that's going to be really challenging to prove because they're going to look at the overall financial status of the entire agency, not just one department, not just this year's budget. Just understand that generally expense has not held up well as an excuse to provide a single purchase type accommodation. It really needs to be considered overall impact on the entire agency and its function. And then finally, an accommodation must be effective. In other words, it does enable the applicant to compete or the employee to perform essential functions. So an employer may not want to give the employee or the applicant the accommodation they're asking for, and they offer something else arbitrarily. But if it's not effective, then they're not really meeting their requirement to offer a reasonable accommodation. They need to negotiate an accommodation that ultimately will be effective if there is one. And they need to exhaust that process. Here's some examples of general accommodations. We often think of an accommodation as a physical change to the environment, like making a facility accessible to someone who has a wheelchair and usable for somebody with a mobility issue. But that could also be assistive technologies for someone with a vision issue, or bringing in simulated natural light for someone with a mood disorder in the winter, possibly. So it could be more than just a mobility thing. It could be job restructuring, moving when essential functions are done. Say somebody is more energetic in the morning, could they do the more labor intensive or thought intensive activities in the morning and do more menial tasks in the afternoon? Flexible schedule for therapy to accommodate the effects of medication, modifying a policy. That would example that would be a service animal, modifying a no animal policy if it's reasonable, modifying a telework policy for just the person with a disability and not everyone. Acquiring equipment, like I said, assistive technology, a sit stand stool, for grocery store clerks. Often they're forced to stand behind the counter, but you know, if they have fatigue caused by a disability, perhaps a sit stand stool or a sit lean stool. Telework, providing other people a reader, an interpreter, or a job coach. Accessing service animals, reassignment to a vacant position. Reassignment is kind of one of those last resort, such as leave is also, neither one of those enable the person to do the job, and those come into play when the person cannot be at work due to their disability. Reassignments when they're not qualified or anymore because with or without an accommodation, they're not able to perform the job. And then leave is granted to recuperate, receive therapy, surgery, train a service animal, get a wheelchair worked on, those sorts of things that would have to be done outside of the job but are related to the disability. When is an accommodation required? When an employer is aware that a person with a disability needs an accommodation to either apply for the job, perform the job, or enjoy equal benefits and privileges of employment, then an accommodation should be considered unless an accommodation would cause an undue hardship for the employee. So for application, it might be a different format for the job interview, getting the questions in advance, getting a translator, not a translator, I'm sorry, a sign language interpreter, something of that nature. Performing the job, it could be a lot of the things that I listed earlier, job restructuring, equipment, things like that. What is enjoying equal benefits and privileges? I'll give you a great example that I experienced in my previous employer. In the break room, there was a table and chairs in front of the refrigerator. It was a large round table. We had a young lady in a wheelchair who wanted to access the refrigerator to store her lunch. She could not get around that table. Her job was not to enjoy her lunch. Her job was not to get to the break room refrigerator. Her job was to go into a classroom and interact with children. But a benefit and privilege of employment is to have a place to take your break. So we removed the large round table and replaced it with a narrow rectangular table that allowed her access to the refrigerator. That's a benefit and privilege of employment. So, okay, disclosure is an important aspect of requesting an accommodation because, you know, generally the individual with the disability must let the employer know, number one, that they have a qualifying disability that entitles them to an accommodation, and number two, that disability is affecting their job in some way, that there's a limitation that's being affected by the job. So it typically includes disability disclosure and sorry, I'm trying to move my notes down here. And it triggers an interactive process. So what is meant by disclosure? It is the act of sharing personal information about a health condition. It's usually to request an accommodation. I do have employees who say, well, when I was hired, I told them in the interview, I have ADHD, and sometimes, I take on too much work and I try to overachieve. Okay, that's great. 6 months later, you're late for work every day, and you expect the employer to connect that to your ADHD. No, it needs to be connected to the current issue, the current limitation. So it is necessary to disclose that you have a disability, and it is important to connect that to a workplace issue so that you get that accommodation negotiations started related to the current limitation. So it's important to understand your rights for disclosure. You don't have to disclose before you need an accommodation. So during the interview process, the application process, generally we don't encourage you to disclose at that point, because if you don't need an accommodation, you don't want any possibility that they're factoring in the fact that they know you have a disability into the employment decision process. But do disclose when it is clearly known that you need an accommodation to either apply, interview, onboard, or be hired in the job or do the job. It is very important to disclose and request an accommodation before performance suffers or conduct issues occur. The example about attendance and the person disclosing they had ADHD but not linking it to their current attendance issue is a great example of that. If their lateness is affected by medication or a side effect of their condition, then talk to the employer about what can be done to assist prior to getting performance, issues that could lead to disciplinary or even termination. Because once they determine that you violated a policy or conduct rule that will result in termination, they no longer have to accommodate you if that's the point you disclose. You want to disclose early on in the discipline process because they are obligated to, provide some accommodation interaction at that point. You don't need to tell everybody in your work site that you have a disability, although that is your prerogative, but it is important you disclose to somebody who can act on the request. Check your company's policies. If you only can if the only person that can act on it is an HR rep, which often happens, they designate somebody, then that's who you should go to. If you want to tell your supervisor, you may, but you also need to go to the person who will be able to act on that. An accommodation request is any request by an applicant or an employee for an adjustment or change for a reason related to a health condition or disability. It does not have to be in a particular format, on a particular form, or worded in a particular way. It needs to clearly articulate that the person has a disability and they have a need related to that disability. The examples here, I'm neurodiverse and I need interview questions in advance. That's a pre-employment accommodation request. I'm having difficulty concentrating because of the side effects of my medication. They may not know exactly what they need, but they're letting their employer know there's a problem. My wheelchair won't fit under my desk. That's pretty overt and obvious. They bring in a healthcare provider's note saying I need 3 months of leave for medical treatment. That's a little bit, I get this one sometimes for employers saying, well, that's not an accommodation request. Well, They're letting you know they have a medical condition, and they're letting you know they have an issue working with it. So it could be, when in doubt, go down the route of interactive process. And then I need to go to counseling appointments, and I want a flexible schedule. Again, that's leave for a medical reason. So it may be an accommodation request. It could be made by the applicant, it could be made by the employee, but request for accommodation may be made by another person. It could be a family member, a healthcare professional, or other representative acting on the behalf of that individual. It could be verbal, or it could be in writing. And no specific wording is needed, as I said earlier. It doesn't have to say reasonable accommodation. It doesn't have to say ADA. It can be similar to the examples I gave on the previous slide. It need not be made at a certain time. And this is something employers get hung up on. They're like, well, they didn't tell me when I hired them that they had, a brain injury, or that they had ADHD, or that they had a seizure disorder. But now they're saying I have a problem, and that's their right. So employers, honestly, you need to get over that, because the law doesn't require they tell you they have a disability until the need for an accommodation is obvious. Sorry, there we go. This is based on the guidance from the EEOC here at the bottom of the page. This is a very helpful EEOC document called Reasonable Accommodation and Undue Hardship that describes what is in this slide. Individuals need to decide how they're going to request. Do they want a face-to-face meeting? Do they want to send an email? Do they want a formal letter? And who are they going to ask? And that, again, that may be based on company policy. They need to explain why they need an accommodation. And if they have ideas, offer their accommodation ideas, and then follow up as needed. And Jan does have templates for all of these processes, okay? And then when requested by the employer, an employee may need to provide medical information when the disability is not overt or obvious. It does say that the employers may ask for sufficient medical to substantiate the need for an accommodation, that this is a person with a disability who's qualified under the ADA. So here's an example of an accommodation request for mental health. I've been having medical issues that have affected mood, sleep schedule, concentration, and focus, and I'd like to request accommodation so I might be able to perform my job effectively before my performance starts. Now, I don't know what employer would not want to hear that I've identified I have a workplace issue and I want to proactively deal with it. So workplace distractions are identified. That's affecting the focus and concentration. I have an idea. I want noise canceling headphones. I want a list ahead of time of things I might need to do to help me stay on track. Let me know if you need additional information. Let me know if you want to discuss other ideas. And could you please let me know next week? You're not demanding it. You're identifying the issue. You're giving some ideas for solutions, which is something Jan can help you with. And then you're asking how they would like to address it and when you would like to address it. And then you thank them. So it's a very, very positively worded letter. That is a great template for a request. So here's an overview of the process. First of all, the employee recognizes that they need an accommodation. Step 2 is to gather information. It might be medical documentation to substantiate it. It might be ideas from the employee, and then the employee and employer explore options and choose an accommodation. Ultimately, the employer gets to have the final say here. They implement the accommodation, and then an important step that is often overlooked is monitoring. It doesn't have to be formal, but it might be a good idea to say in 3 months, we're going to look at the effectiveness of this, but the employee can come forward anytime to say that there's a problem. So what does the interactive process entail? Because the law says that there should be an interactive process to determine effective accommodations. So when an accommodation is not obvious, an appropriate accommodation is best determined through this interactive process. Look at the job. What is the purpose of the job? That'll help you determine the essential functions of the job. Like my example for the benefits of employment, getting to the staff fridge wasn't an essential function, but it was a benefit of employment. So it is included as something that needs to be accommodated. But, you know, perhaps somebody is just having issues sorting mail, but this is just a marginal function that they do filling in with others, you know. I mean, can you take that duty away, or can you get them an alphabetical sorter, you know, or something like that? So really the individual with a disability often has the best knowledge about how their limitations are affecting them. Medical documentation may shed some light on that, but often the individual is your best source for information. Collaboratively identify potential accommodations. This is also a place where Jan can really help you on how, you know, to come up with ideas and work together. Consider the preference of the individual and then select and implement the accommodation that is the most appropriate for both of you. It doesn't have to be their preference if you can find another effective accommodation to replace it with. So communication is so important, and we often say in Jan, nothing really replaces a good, thorough conversation with the employee about their needs. And so when things are farmed out to third-party vendors and HR contractors, sometimes this is hard to do, but it really does not have another replacement that is more effective than having a conversation with that employee. Again, both parties can come up with ideas, and then, you know, the reasonableness of it is based on that agency's functions, purposes, and business necessity. We do have a great resource on our homepage of both the employers and the employees, I believe, the FAQ of basic ADA accommodation questions. Medical information, again, is allowed, but not required. You may request information from a medical professional. They don't define specific medical professionals. It just says the medical professional should have expertise in that individual's disability. So it does list examples, obviously medical doctors, psychiatrists, psychologists, social workers, rehab professionals, nurse practitioners are all listed as possible medical professionals that could provide ADA documentation. If you ask us who can provide medical documentation, we are going to copy and paste that out of the EEOC guidance, and it's not exhaustive, and it doesn't give you a concrete list. So you do have to use some discretion on that. You may not ask for the whole medical record, obviously, but you can ask for information specific to that impairment. If the employer asks too much, then the employee can push back if they feel that they've given enough information to verify they have a disability and it limits at least one major life activity. So here's some examples of some of our publications, because this is a hot button topic, sorry, is getting that medical. And some employers, they're like, I can't go forward, I don't have medical. You can go forward without medical. It's an option. If you choose not to, yes, you have a basis for that. But if you really think that this person has a valid case, then you can certainly go forward without the medical, or you can do a temporary accommodation pending medical. Then again, we keep using the word collaborative, but collaborative solutions, collaborate to identify solutions, working together, look at external option. There are voc rehab offices all over the country that will help people specifically with vocational training and resources with disabilities. Assistive technology projects are in every state. So those are some resources, and Jan, of course, is available to discuss accommodation ideas. If you're the employee, you want to be prepared to explain what accommodation you need, how it will address your limitations and abilities, what accommodations you've tried in the past. For people with neurological cognitive disability, sometimes they have experienced things in educational or vocational settings that worked well that may translate to employment. So are there any workplace changes that would be helpful in minimizing the impact of your health at work? Maybe moving your office away from high traffic, something of that nature. Or are you open to discussing alternative accommodations? Because if you say telework's the only thing and nothing else will help, you've got to be careful, because if the employer has valid reasons that that cannot be allowed, you've painted yourself a bit in a corner by saying you have no other options. Here's an example of our A to Z page on our JAN website by disability. And there is a tab for brain injury on here. And then by limitation, if you go to that page, it'll have things like concentration, light sensitivity, noise sensitivity, fatigue, stamina. By work-related function, that might be reading, writing, sitting. And then by topic, it's a smorgasbord. You know, it's service animal, it's telework, it's all kinds of things. FMLA topic is go there if it doesn't, if you don't find it anywhere else. And then finally, accommodation. If you go way back to the beginning of my presentation, and I had that slide that said things like job restructuring, telework, it had scheduling, accommodation, all of those are going to be listed there with some EEOC guidance on what those look like. We also we have a tab I mentioned earlier called situations and solutions. And one of the things that's neat about this is like you can go to it by occupation. So if I were able to click the occupation button, I could go down to retail, and then I could have like grocery sales or clothing and different occupations, and give some examples. Now it's going to be all different disabilities, but it's going to give you an idea of what accommodations we've brainstormed with some specific occupation. But you can also search by disability and look at all the different examples in our solutions pages by disability. So choosing the accommodation. When possible, we encourage employers to choose the accommodation that the employee prefers, but they may choose among effective accommodations. Consider implementing a trial period if it's not clear that the accommodation will be effective. That shows that you have good faith for both parties to try to work it out and see if it'll work. And we do have a publication called Temporary or Trial Accommodation that will outline what that can look like. So what if the alternative accommodation doesn't work? The employee should inform the employer that the alternative accommodation, not their preferred accommodation, wasn't effective. And it's very useful to notify the employer in writing and explain why it's not working. Ask for the original accommodation to be reconsidered if it is reasonable, or open the negotiation to discover if there's any other accommodation. And we have a template and a guide for this called How to Inform an Employee that an accommodation is not effective, and it has a sample letter. So when an accommodation is denied, that can be very frustrating for the employee. We recommend the employee ask for information about why it was denied, see if they can provide any additional medical or other information, perhaps offer to renegotiate another alternative accommodation. And if the employer is not accommodating them after the denial, or continues the denial, the resource at the bottom of the page has information about how to appeal, how to seek legal support, and ultimately how to file a charge. Communication, again, I cannot stress it enough that communicating between the employee and employer is often the best resolution for finding a good solution to an accommodation issue. So staying open-minded, adaptive, creative. There is no one size fits all. If you know one person with a disability, you know one person, and everyone is going to be coming in with unique limitations, and every job duty is different. So it's just important, and the intent of the ADA interactive process is to have this interactive, collaborative type resolution to the accommodation question. We do have a resource on communication at the bottom of the page too. Okay, I'm just going to flash these on here because there's a lot of them, but we do have a lot of resources going from the employer to the job applicant to the employee to just general information. Plus, we post all of the EEOC resources on our website. Here's another page of resources, different ones for how to request an accommodation. One includes a form letter, sample language for accommodation request. I have found people to find that sample language for accommodation request to be one of the most useful things, because it's just, how do I word it? And that's got several examples for physical, cognitive, mental health, that just give you that wording. Because there's no fancy way to do it. It's just saying I have a disability and I need something, and that's hard. People want the right way to do that, and they don't really say there's one right way to do that. We have guidance for medical professionals. What does that look like when you're getting an accommodation request? Most doctors know how to write this, but there's no, again, one right way to do that, but they don't always know wording wise what's the best way. So we've developed a pub on that. So we are Jan. Again, you can reach us by email at jan@askjan.org. 800-526-7234 will get you directly connected to a human being. We still have PAs answering our phone. The live chat at askjan.org, and if you just go to our website, askjan.org, you'll find the portal for all of those different ways to connect to us. So I think that concludes the slide presentation, and I am open for any of the chat questions if we want to discuss any of those.
Thank you so much, Lisa. This was really wonderful and in such an incredibly important topic for our Iowans navigating life after brain injury. Really just want to say thank you for sharing your time and obvious passion with all of us. We do have some questions that I have been taking note of. The first one is, the requirement of a driver's license to apply for a lot of jobs is a real problem. And there's a big debate about whether driving is an essential function of a job. Is this still taken on an individual basis, or is there a statistical percentage of how much driving is an essential function?
Oh, that's a great question. I'm not aware of a statistical amount that says, because here's the deal. Landing an airplane is a very small percentage of the time that a pilot spends in his job, but it's an extremely important task. So a time or percentage amount isn't always, critical to determine whether something is an essential function or not. So driving and essential functions, again, going back to, okay, here's an example I deal with a lot. An individual's job is to be a social worker and to go into the homes of families with young children. To get to those homes, she needs transportation, but driving is not her essential job. Now, if I was hired for a mail carrier or UPS in a rural area, delivering packages by truck is going to be an argument for that being an essential function, right? So, it is very case by case based on the job duties and the argument that the employer can make for it. But, we do get calls about vision or seizure activity limiting somebody's driving. And if because I understand Iowa is rural, just like Missouri is rural. I worked in a home visiting program. The employees drove their vehicles to those homes. I get that's a huge issue. But to say you can't do the job because you don't have a driver's license, is that a true statement? Because they can, when they are in the home, do the job. Now, if you can't find a viable solution to them getting in the home to do the job, then that's an issue. But just to blatantly say no license, no job, is that reasonable? And I can't answer it because I'm trained in education, folks. I'm not a legal person, but I'm just saying, you got to break it down to what is the essential job function and can it be done a different way? And really look to determine whether it can be done a different way. During COVID, we did those visits via social media, or not social media, but Zoom, WhatsApp, different things like that. Not the best though. And you don't have to settle for the least effective way to do the job, but you do need to consider thoroughly any alternatives to this person having their own ability to drive, if there is any. That's the main thing. You just don't want to make a blanket, you can't have this job if you can't do that.
Good answer. Thank you. Another question that came in was, how does this work with employees who have union as well? Does the employee utilize the union to intervene in some of these attempts?
They do sometimes use it as a resource. One big thing with unions is, the power of a union is pretty powerful, because say a person is working night shift and they need day shift due to their sleep issues, right? If the union has a seniority system for day shift jobs or not working overtime, for example, if the union has a seniority system for that, that is one instance where that trumps somebody's right to a reasonable accommodation. In other words, they can't jump across the seniority system for their accommodation. But I do often hear from employees who say that their union rep is trying to help them navigate their accommodation. It's not written into the ADA anywhere else other than what I just said about seniority systems not being trumped by it. But, an employee can use any resource that they have. I would just say, if you're planning on having a union rep come to anything your employer is requiring, like a disciplinary meeting, that you ask for an accommodation, because all accommodations have to be asked for. They're not automatic. Now, what if the union allows that? That's different, because I don't know union rules, but you would want to assure that you have permission for a support person. That's what you're really asking for, is having a support person help you.
Great. Thank you. Lots of engagement in the chat box. This is great. Thank you, everybody. If an employee does not utilize a requested accommodation for a period of time, can an employer end the accommodation?
No accommodation is ever carved into stone. So needs change. And that's why monitoring accommodations is a pretty important overlooked aspect of the accommodation process, because business needs may change. And I get that a lot, where, my job changed and now I have to answer the phones and I have anxiety about that. But the employer has a right to change jobs, to change schedules based on valid business need. So if you've gotten the accommodation and you're not using, the question begs as to why you still need it. Um, if it's something just intermittent that occurs, I would just get that clearly defined that even though you haven't used it, the need hasn't gone away for it to be an intermittent need, and just get that solidified as to when and how that accommodation would be accessed.
Great. And then the last one is a TBI survivor, traumatic brain injury survivor, sharing that he had an accident in 2005, was a college professor at the time, recently retired just due to struggles around work, but is now currently seeking work again. Says, I don't know if I would be classified as having a disability, but recognizes that he needs a less stressful job than he had. Where
Mhm.
might somebody like that start with,
I think,
yeah, no, I'm
yeah, vocational rehabilitation might be a great place to check out. That is a great example of what vocational rehabilitation often does is say somebody was doing assembly work and injured one arm and can't do assembly work but they want to work, so it's vocational rehabilitation. It's rehabilitating somebody to change vocations, and job retraining is a big part of that. So that might be a great place to go. The counselors at Voc Rehab are typically schooled in, I think they have to have a master's in rehab or related field to be employed by Voc Rehab. And they may be able to help him determine what area of vocation he's now suited for and if he does need any accommodations. And I believe they often can do assessments to determine if you have some limitations from your prior injury. So I would suggest that. We do have a job seekers page on our website as well. It's under the individuals page. When you go to the tab at the white tab at the top, and there's employers and then individuals, and then off to the left side there's a job seeker tab in addition, and it has a lot of we're not a job placement service, but on that there are several links to job placement services. So that might be helpful as well.
Well, thank you so very much. You have been a wealth of information, and thank you for carving out time to answer questions. And thank you to everybody who attended today for your time and for your engagement in the chat box. I just posted the link to our post webinar knowledge check. So make sure that you complete that before tomorrow at noon if you would like a CEU. And if you have any questions, please reach out to me at the email address in the chat box. Thank you so much again to our presenter today, and thank you all for being here. Really appreciate it. Bye-bye,
Thanks
everybody.
for having me. Bye bye.
Thank you.